Welcome to Dr. TSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello, and a warm welcome to our esteemed guest B.V.ACHARYA-ji, 5 times Advocate General, and he is a big name in the legal fraternity circles. So many awards and rewards because of his brilliance in his legal academics, and former Jayalalitha's case is also in our memory, and he is always there whenever there is infringement of the constitution vis-a-vis the rights and justice. So we are late by few minutes because again, as and when we announce an important show, the governments, how they act, all of a sudden their power goes and all of a sudden the power comes back. This is nothing but to create a sort of situation wherein I lose the bandwidth and I lose the guest. But in spite of that, again, I am very much thankful to our honorable guests who have been coming regularly on DSPR channel live shows, so that the public, the constitutional authority, every citizen is a constitutional authority, becomes aware of his rights so that he can seek justice. In the same vein, today's topic is of utmost importance. We have seen Supreme Court judgment over PMLA Act, we say, for commoners' money laundering. Why this show is so important? Is it infringing the personal rights of the citizens? Yesterday also we were doing a show, I was mentioning Kasab, who was caught, a Pakistani terrorist. Red-handed he was caught, but in the name of principles of natural justice, you have seen how our system has provided him advocate, and he was hosted for such a big time in AC halls. Similar was the Bombay terrorist attack case. Midnight Supreme Courts were functioning. But what the same justice system, why is that it is not being provided to others, commoners, or those facing various other cases? May not be that serious, but at the same time, of late you have seen how the basic rights have been infringed and making those who are seeking justice to suffer because of these orders or not proper understanding of what is there in the constitution when it related to justice system. Welcome, sir. Yes, sir. Now you can go ahead, sir.
Good evening, everybody. Today, the topic that is selected for the lecture is very recent judgment of the Supreme Court upholding the validity of the PMLA, that is Prevention of Money Laundering Act, with all their amendments which have been brought about. Though the provisions of the Act have been challenged on various grounds, after hearing the matter in great detail, the Supreme Court has chosen to dismiss all the writ petitions, thus upholding the validity of the Act. Now, not only I, but many persons who are well aware of constitutional provisions and the law are of the opinion that the Act in question contains so many provisions which take away or abridge the fundamental right of the citizens, particularly with regard to personal liberty, which is one of the most cherished fundamental rights. So many, within the last few days, there have been so many write-ups and editorials in newspapers in which this verdict of the Supreme Court has been assailed. In fact, few days back, one article with the caption, an erosion of constitutional buffers. Another, today itself, I found a write-up under the heading, due process will be bulldozed, because nowadays this bulldozing has become a very common expression. So virtually this is a case of bulldozing of the due process of law. In view of the importance of the matter, for a common man whose fundamental rights are violated, the case becomes important. That is why I am before you to just explain the effect of these enactment and the effect of the Supreme Court upholding the provisions of the Act. Now, what is PML Act? That is an act enacted for the purpose of punishing those who are dealing with proceeds of a crime. So it presupposes there is a crime committed and unlawful gain by that crime is being misused or used by the persons projecting the money as an accounted money. What is tainted money is projected as a lawful source of money. It is to detect these crimes and punish them, and also second objective of the act is to confiscate the properties that are acquired by use of this tainted money. Now we are here not concerned with the confiscation of the property wherever they find that it is from out of the proceeds of a crime. But our main concern is with regard to the penal provisions relating to search and seizure, provision relating to arrest and offense and penalty, punishment that can be imposed by a criminal court. These are aspects which affect the common man. Therefore, I thought it is but proper that an ordinary citizen must know the implications of this act. Now, to begin with, I would say, just like any ordinary criminal proceeding commences with the police by filing a FIR. That is known as first information report. That is, the authorities start the investigation with draft report which gives particulars of the offense as has come to the knowledge of the police. Now, in the present case here, the authorities under the PML Act are commence the whole proceeding with what is known as ECIR. That is a secret document that they are preparing. It is equivalent to the FIR because with this ECR, the proceedings commence. Now, generally, when there is a FIR, it is to be immediately sent to the magistrate. And once the FIR is copies with the magistrate, nobody can tamper with it. And it becomes a public document. An accused or any other citizen is entitled to a copy of the FIR to know what the contents are, what is the offense, what are the charges. But in this particular case, under the PML Act, this ECIR, which is the most vital document with reference to which the proceeding commences, nobody is entitled to look into it. No copy will be given to anyone, either the accused or witness or any member of the public. And it is kept as a secret document with the authorities. And when a person is arrested, even after arrest, copy is not given to him. On the other hand, the special judge before whom the accused has to be produced within 24 hours after arrest, when his further remand is sought for by the ED authorities, the magistrate is entitled to look at them privately, secretly, without giving copy to the accused. The result is the magistrate, based on what ECR contains, which is what is written by the authorities, without knowing the same, without bringing the same to the notice of the accused, remand is ordered. That means secretly a ground which is mentioned by the authorities is accepted as correct without opportunity to the accused to have his say in the matter. This is totally opposed to principles of natural justice. But such a procedure is contemplated, and this ECIR remains a secret document which is used for taking away your liberty, remand you to custody for 2 weeks or thereafter. But that what it contains, you don't know what they have written about me. Now, this is the first point on which I submit, and almost many people who have written about it are convinced the first erroneous decision of the Supreme Court is it upholds this provision of keeping the document secret. It very seriously affects the right of the accused to show that what is contained in the ICIR is not true. I don't know what it is, so how can rebut it? Now, by upholding such a secrecy, what the Supreme Court has done is it has given preference to secrecy as opposed to fairness and transparency. And it totally violates the principle of natural justice. Next, I'll come to the scheme of the Act under which very valuable fundamental rights guaranteed to the citizens are denied to the citizens. They are particularly Section 19, 24, 50 and 45. These sections taken together deprive the citizens of valuable fundamental rights guaranteed by the Constitution of India. That is one aspect. The other aspect is these provisions dealing with arrest, dealing with burden of proof, dealing with the recording of statement of the witnesses under 50, then Section 45 regarding bail. These are the provisions which vitally affect the citizens so far as personal liberty is concerned. So these penal provisions in this Act have a vital departure from the general law. Now, our country as well as elsewhere, criminal jurisprudence is founded on some basic principles which are considered fundamental in criminal jurisprudence. The first one is presumption of innocence. That is, a person is presumed to be innocent unless proved guilt. That is the accepted position. Then second is, when the state prosecutes a person and wants him to be sentenced to imprisonment or fine, the burden of proving guilt of the accused is always on the prosecution, and settled law is that proof required is proof beyond reasonable doubt. The third is right of bail during trial. A man should not be in detention before conviction. It should not be a punishment. A punishment can be only after the conviction. So during trial, generally, an accused is entitled to be on bail. Now, as we have said earlier, even Supreme Court has accepted the position that bail should be the rule and jail is only an exception. And the last is Article 23, which says no accused can be compelled to incriminate himself. He is entitled to remain silent, and you cannot compel him to confess to the crime. If he voluntarily does it, it's a different matter. But you can't compel him to do so. Now, all these four basic fundamental principles of law are contradicted by this act. These four important safeguards or fundamental principles of law, the act goes totally contrary to it. And such provisions are upheld by the Supreme Court. That is the crux of the matter. Now I will come to the first point. I have already said keeping it FIR, ECIR secret is the one thing. Now next is the provision of section 50 of the Act. This is important. Under section 50, once ECIR is registered, the authority has all the powers of a civil court. It can summon anybody to give evidence, and the person summoned is bound to appear before him, even whether he is a witness or an accused. Even an accused, when he is summoned, he is bound to appear. 2, he must give evidence on oath, saying that he is telling the truth. If the evidence he gives is not true, he is liable for perjury, because the proceeding under 50 is a judicial proceeding. And he cannot avoid going before the authority and giving some. Now, the authority summoning you actually know whether you are accused or witness. But the person summoned doesn't know. He is not to be told. If it is said that he is an accused, then under Article 20 he has the privilege of not incriminating himself. In this case, deliberately this scheme is made. You don't know whether you are a witness or an accused, and you are bound to answer all questions. And the most important thing is, since it is a statement on oath and is recorded by competent authority, the same can be used as evidence against you throughout the proceedings, which is not possible if you are an accused, because you can't put a question to him and compel him to answer, because the accused has the right of not self-incrimination. So, to circumvent the law which gives protection under Article 23, Section 50 is designed in such a way that you just summon a record statement of oath, use it against him later on. This is the way the fundamental right guaranteed to a citizen is overcome. Now, under the general law, criminal procedure code, and the proceedings under that, law specifically says, Section 25 of the Evidence Act, no statement made by an accused to a police officer is admissible in evidence. Because when you are in custody and even otherwise, when police officers comes and record a statement, which is called a confession, you know the value of it. It may be obtained by threat, coercion, and it will be very difficult for a citizen to prove that it is threat or coercion. Therefore, Section 25 totally debarred an accused statement given to police officer being used. It can't be used at all if it is a confession. Now, to get over that, what they say here, the ED officials, they have got power to arrest. They have got power to send you to court and seek remand. They have got power of search and seizure. All these powers, and they can prosecute me. All these they are doing. Therefore, the contention before Supreme Court was that when the authorities under the ED record the statement, if he is an accused, then the statement should not be admissible because they are virtually police officers. Now, Supreme Court says, no. At that stage, when your statement of recorded, they have not shown you as an accused, and they have not arrested you. Therefore, they are not police officers, and Section 5 doesn't apply, 25. Therefore, this very statement which you have made can be used in the, this is how, unfortunately, Supreme Court upholds an scheme or the action of the authorities to circumvent the law. That they should not have done. In a similar provision under the NDPS Act, Supreme Court itself said, though they are called excise officers, since they have got all these powers of the police, they are police officers within the meaning of Section 25. But that is also departed from. Every provision generally applicable to criminal law is given a by this Act, and the Supreme Court blindly upholds all these provisions. This is Section 50 is thus a drastic provision virtually circumventing the fundamental principle of law. Now that section is also totally upheld by the Supreme Court. Then comes Section 24. Now, as I said earlier, it is the settled law that the burden of proving any case is always on the prosecution, and the defendant or accused can keep quiet. This is the fundamentally accepted position. Now, Section 24 of the Act reads as follows: burden of proof. It is totally reversed. In any proceeding relating to proceeds of crime under this Act, A, in case of a person charged with offence of money laundering under 3, it is enough if they just say he is the person who is guilty of money laundering. In case person charged under Section 3, the authority or the court shall compulsory, mandatory, authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. In case of any other person, authority or the court may presume that such proceeds of crime are involved in a money laundering. So this is a burden of proof placed on the accused. First presumption is he is guilty and it is the proceeds of money laundering. So he has to prove that I am not guilty, I am innocent. This is a presumption contrary to the well-accepted principles above. Now, arguments have been advanced to show that this provision is invalid, but somehow the Supreme Court has accepted this provision also as a valid. This is another fatal draconian provision affecting the right of the accused and going contrary to the fundamental principles law. Then, third and the most important provision is section 45. This deals with bail. This is a very important provision. Now, under the Act, in case trial goes on and there is conviction, the punishment is up to 7 years or 10 years. Now, even in a case of murder, rape, or any heinous offense, an accused could be granted bail, though the sentence is much more. But here, there is a restriction placed on the power of the court to grant bail. Trial, as we know in our country, goes on for years together. Therefore, unless bail is granted, a person will have to be in custody for several years. That's why the courts have been liberal in the matter of grant of bail. If the person can be secured at trial and he is not likely to tamper with evidence, bail is granted as a matter of course. And before considering the bail, the court will find out whether the prosecution case as put forward is satisfactorily established, or at least there is a prima facie case against the accused. But in section 45, two conditions are laid with regard to bail. It says notwithstanding anything contained in the code which permits grant of bail, no person accused of offence under the Act shall be released on bail unless the public prosecutor, unless the court is satisfied that there are reasonable grounds for believing that he is not guilty. So, accused satisfied that he is not guilty, then he will be granted bail. How can that be possible? The burden is on the prosecution to prove, and ECIR, a secret document, is with them. Even the copy is not given to me. Yet, for the purpose of bail, I must prove that I am innocent and that he is not likely to commit the offence while on bail. These are the conditions. No lot of argument was advanced. This section was once struck down by the Supreme Court. That is a judgment of Justice Rahington Nariman. He said it is discriminatory because it made difference, predicate offence and offence under the Money Laundering Act. There were two classifications. So it was struck down. Secondly, Justice Nariman has held that this provision is manifestly arbitrary. Now, so courts are entitled to strike down a law if the court finds that the provision is manifestly arbitrary. That is one of the grounds on which now the section 45 after struck down, they again reenacted by way of amendment, making some verbal changes. But the fundamental defect that it is manifestly arbitrary still remains. But the Supreme Court says where some defect is pointed out in a section, by rectifying that defect, the legislature is entitled to reenact it in a different form, taking away the basis of the earlier judgment. Based on such a presumption, the Supreme Court has now held that this amendment is not bad. Section 45 as it is today is valid. And after brief discussion it says this provision cannot be said to be unfair or arbitrary. According to my submission, it is manifestly arbitrary to put the burden on. Then a similar provision is there in NDPS that he should prove that the court must be satisfied he is not guilty, or in the offences relating to Terrorist Act. Now, the Supreme Court says the act of money laundering is as heinous as a terrorist act. Therefore, it equates to terrorist act for upholding this provision. Kindly see whether any common person can say that you equate the act of terrorism where death sentence is provided, where a person may kill so many people with one blast, a case of money laundering where the punishment is either 7 years or 10 years. This is the provision which again is totally opposed to criminal law. Now, almost all contentions of the government have been upheld. In fact, the judgment comes into 500 and odd pages. Instead of writing such a lengthy judgment, the Supreme Court have only said all the contentions of the state, central government are upheld. All the contentions of the petitioners are rejected. Therefore, the petitions are dismissed. It was said like that. But only in this bail, one small mercy is shown to the accused. See, knowing that in our country, trial goes on for years together, and an accused who is denied bail may have to be in custody under trial prisoner for a period larger than the maximum. Say, for instance, here, maximum may be 7 years. Some cases may go on for beyond 7 years. Therefore, the Criminal Procedure Code was amended and Section 346A was added. By that it said, Section 436A of the CRPC, it came into force few years back. It said, where you are under trial and you have been in jail for more than half the period of the maximum sentence, then immediately you are entitled to bail. So here also, the central government said, even that 436A is not applicable to this act. Supreme Court said, no, that we will make it happen. So, if the sentence is 7 years, after 3.5 years, you can be released on bail. To that extent, one small mercy is shown to the accused. And second small mercy shown is the whole act comes into force only if there is a crime and proceeds of the crime is used. Then becomes an offence under this act. Now, if the main crime itself, the case ends in acquittal, what will happen? There, the Supreme Court said, if that ends in acquittal, then there is no crime at all. Then the act can't apply. These are the 2 points on which the Supreme Court has shown small mercies on the citizens as against the state. But for that, almost every contention that was urged for the petitioners have been given a go by. See, during the last few days, as I said, there have been several write-ups and editorials. In fact, the editorial of Deccan Herald, 2 days after the judgment, the heading is Supreme Court must review the PMLA judgment. And they pointed out all the infirmities in the judgment of the Supreme Court. Similarly, so many other write-ups are also there. In fact, in my article on the subject, I have concluded like this. In the ultimate analysis, the Supreme Court has allowed the government to achieve its evil design to render several provisions of the Constitution, in particular Article 14, 20 and 21, irrelevant and odious so far as the Act is concerned. One is reminded of the judgment of the Supreme Court in ADM Jabalpur case. You must all be knowing about this famous judgment in ADM Jabalpur case, where during emergency, when the state said that during emergency, Article 21 can be suspended. Therefore, even if the state shoots you and kills you, you have no remedy. Now, such a draconian provision was upheld by the majority judgment of the Supreme Court, which was widely condemned all over the world. But there at least there was one silver lining, that was there was the dissenting judgment of Justice H.R. Khanna, who said this is not correct. Life is something inherent given to us by God. Emergency or no emergency. No state can take away the life of a person. And immediately thereafter, Janata government came and this provision was rendered redundant because of that. But in the present case, there is not even a dissenting judgment. All the 3 judges have upheld this provision. Now, all that I have said is regarding the legal aspects of it. And my conclusion is, the present case is yet another instance where the Supreme Court has upheld the validity of several draconian and oppressive provisions in this Act, which enable executive excesses. It helps the executive to commit excesses and denies to the citizens fundamental rights guaranteed under the Constitution. And all these are the views of the legal people who are well versed in law. But as a common man, what is the impression? I will read only 2 sentences in a letter to editor by the common man. It says, Supreme Court on PMLA. The judgment of the Supreme Court on Prevention of Money Laundering Act shows on whose side the Supreme Court really is. It is consistently protecting the authority rather than the citizens. It looks like India is an elected police state rather than an elected democracy, where the citizens have all the rights in a democracy and the government all the duties. But here now the government has got all the rights and the citizens all the duties. This is in substance what a common man feels about the judgment of the Supreme Court. It is not in favor of the citizens, but on every aspect of the matter, whatever the government or the authority has said is upheld, and the rights of the citizens are taken away. Therefore, one more aspect we want to say, these Act has so many amendments. Many of the amendments were passed as money bills without going to Rajya Sabha, where the government had no majority. Now, whether these could have been passed as money bills, because the Speaker has certified, is pending before the Supreme Court. And Supreme Court itself, in this very judgment, they said, so far as the constitutional validity of these amendments as money bill are concerned, they have been referred to a larger bench of 5 judges. We are not touching upon it. The constitution bench will decide. Therefore, even today, the matter is before the constitution bench of the Supreme Court regarding the amendment. If it is held that as money bill it could not have been passed, then all these will become illegal. Therefore, what was the hurry to uphold these provisions when the main provisions of the amendment are still pending before the Supreme Court, the Constitution bench? Therefore, I am appealing. This judgment also requires reconsideration. Let it be reconsidered along with the validity of the amendments which are already before the Constitution bench. I hope some of the petitioners will file review petitions before the Supreme Court, and those review petitions must be placed before the Constitution bench along with the connected matters, in which event, once and for all, the 5-judge bench of the Supreme Court can go into all these matters and take a decision. Therefore, I appeal to the Supreme Court to reconsider the whole matter, review the judgment, and do justice to the citizens. Thank you very much.
Wonderful, sir. It is really, I think you have made it very, very clear the need for the review of the Supreme Court order, and it very clearly states that the matter is all these amendments are pending before the 5-member constitutional bench in the same Supreme Court. But what is the hurry of this 3-member Supreme Court judgment? They themselves have to introspect. Why? Because very clearly stated, even Rajya Sabha, what happened, whether it is in the form of money bills and all, whether the elected representatives are not aware as to what are these amendments amounting to, and how can an officer force a citizen to prove his innocence? That is what is very clear. How can I prove my innocence? That is one aspect. But how can I prove innocence without knowing what case is registered against me? I hope Prime Minister Modi will understand. Even if he doesn't understand, he needs to have advisors and all his ministers. Such a vital bill, I am right away putting it across to all the members of the parliament and all the assemblies, all political parties. If you don't understand, then people will rise above. There will be another big struggle like what we have witnessed in the name of emergency. Because it is nothing but, again, you are creating emergency, bringing out such draconian laws day in and day out. Why are you afraid? Whom are you targeting? Your own citizens. Mr. Modi and all those elected representatives in the parliament and assembly. Kasab, the Pakistani terrorist who was killing people, caught on camera too, what he was doing. What did you do? UPA, what are you? I think it's a sleeping deck now. They provided such beautiful accommodation and he was demanding and getting biryanis and everything. You have even given him a advocate. Legal aid services were provided to a Kasab terrorist. Then what are you doing in this money laundering act? I think it is just shaming India now. India is a democracy, come on. How different this Indian citizen is when you compare to Kasab the terrorist. How is that when someone is arrested under this act as upheld by Supreme Court? How is that citizen doesn't even know under which provision he is being arrested? Okay, money laundering. But in which way? There should be information given to him. And when you have...
In practice,
Sir.
In practice, what they do is, you are summoned under Section 50. Okay. Your statement is recorded on both. And you must have seen in newspapers,
yes,
the recording statement is not half an hour, 1 hour. It goes on for days together.
Yes.
See, third time, fourth time, fifth time. And at the end of the day, on the 10th day, night at 12 o'clock, you are told, your statement is complete. Now I have got this evidence, you are arrested.
That's what
Then only becomes arrested person. Till then, you record the statement. This is how law is circumvented.
It's really
And
shameful.
thereafter again, you ask for police custody on the ground that he has not cooperated. Cooperation means what? If you confess the crime, you are cooperating. If you say, I have not committed an offense, you are not cooperating. And the judge will remand. This is the practical way of doing things.
Yeah, this is what shameful. That's what we are trying to bring it to the notice of all parliamentarians and those elected to the state assemblies. If you don't understand and don't correct these type of draconian laws, people will start revolting. Believe me, the same treatment which you have provided to Kasab, a terrorist, is not being provided to your own citizen. Yes, confiscation is there, everything is there, tainted money. We will all agree.
No,
We all agree to that.
those who make these laws, just they think that they will be in power throughout.
That's what.
They do not anticipate that tomorrow you may be on the other side. Today the law is being used against your opponents. But you can't be sure. It is a hope of everybody that he will be in power always, next 20 years or 30 years. But that is not happening. We have seen past experience. Even Mrs. Gandhi so hopelessly lost the election. Within 3 years, she came back to power. So you must always think in the larger interest than your self-interest. Today you may be in power not affected by the provisions, but tomorrow...
Very well said. Power is not eternal. How long you are there in the power, no one knows. So I hope better sense will prevail on these enactments, and even Supreme Court should consider reviewing it. And because Supreme Court should not play with the sentiments or rights of the people, you have to see to that the commoners do not lose faith in judiciary. It is there in the hands of Supreme Court now. Already a larger bench, constitutional bench, is there to look into these amendments. Then what made these three judges? There is no dissent judgment in these three. That is what is really perplexing us. No dissent judgment in this three bench, unanimous. Arey yaar, common man, I am putting it to those judges and all the parliamentarians. Kasab was provided principles of natural justice, you say, to show to the world. How is that the same is being denied to your own citizens? Why should I prove that I am innocent? You prove, is it not the duty of the prosecution? Then is it prosecution sleeping? That means just make an amendments to the act and you threaten people, threaten citizens. If you don't listen, you will be jailed under this law and that law. Is this democracy? Is there rule of law? Is there a proper trial, a transparency in trial? Can justice system be like this? That is what he was questioning. In whose interest? Is this going to be a police state or people participatory constitutional democracy? People will understand this. We have seen the scientist, rocket scientist Nambi Nayar's his case also we have seen, and he is very clearly stating, if I am the villain, now I am acquitted, then who is the villain? He is very right. You made me villain, now you are acquitting me. Padma Bhushan has been given. Even Kerala government comes forward 1.03 crores compensation. But who is the villain in making Mr. Scientist Nambi a villain? What is this happening in India? Is this the way judicial system, justice system runs? People have faith in judiciary. I only hope Supreme Court and High Courts and all those right from magistrate to High Courts to Supreme Courts will see to that the commoners' faith in judicial system will never go away. By these type of enactments, amendments, draconian laws, if a state makes, if a parliament enacts, and if the bill comes to you, there should be a proper trial, as rightly pointed out by him. You should allow the accused, you should be given the information. This is what we have seen during Chidambaram. The same Chidambaram Lipafa envelope case has engulfed him also. When he was Home Minister, the same thing was done to Amit Shah. Now after he came back to power, the same envelope. This is against criminal procedure system. As the CRPC I say, procedural code. You are not allowing the accused to know under which sections, what are the provisions you have enacted that act, or you have arrested him, or you are calling him for investigation. You don't give him any information, neither to the accused nor to the lawyer. And here also in peculiarly, you do not even know whether you are accused or witness. And that too again it clearly states on oath. Oath should be judicial process. But here officials, they are taking away the functions of all the courts. That's what I've been telling. By these draconian laws, you are not allowing judiciary to be independent with trial and justice delivery. When that happens, there will never be democracy functioning. It will be just autocracy. And I only hope before people start hitting the roads, these type of draconian laws and these type of Supreme Court judgments will have to be reviewed. Otherwise, people will literally be on the roads. If he doesn't know under what sections he is being arrested, and he doesn't know that even his lawyer will not be able to get any information. It is a secret document. When it is a secret document, they are calling you for as a witness or accused. That also you do not know.
They say, Supreme Court says, after the arrest, he will be told of the ground of arrest. Not till then.
What is this?
That is sufficient. That's what Supreme Court says. After arrest, he will be told, probably orally, what the charges.
This is really, Supreme Court has to understand. We are bound by the basic structure of the Constitution. under which everything runs. If Supreme Court bypasses that, I only hope God will save these so-called 3 pillars or 4 pillars. And if one pillar starts acting in such a draconian way, what happens? Will people participatory constitutional democracy survive? It will survive. How? When people start agitating, as they have done in the case of emergency. Now this silent writing of amendments in the name of draconian laws, again mimicking emergency, people will understand. They will definitely start reacting. Before they react, Supreme Court should immediately review, and even the parliamentarians and all those as elected to the assembly, all those politicians, whether in opposition or in ruling, if you don't understand, you are just a minuscule. You are elected by people. You are not the bosses. Mind you, every citizen is a constitutional authority. You are just a public servant. And public servant, even IAS or IPS, whoever it is, they are all public servants. If public servants start imposing their culture, their draconian laws on the bosses, the people or citizens, people will not keep quiet. They will come back, and that way we will be making a mockery of our own people participatory constitutional democracy. We have seen what is happening in Sri Lanka, and elsewhere also we have seen how it has been. Now I only hope Indian parliamentarians and all those elected representatives, including the High Court or Supreme Court, whoever it is, will always try to see to that there is no infringement of fundamental rights, that there be a fair trial, there be a transparency, so that everything is accountable. Otherwise, people will be on the roads. We may witness another struggle like what we have witnessed during emergency days. Thank you very much, sir. So from here, this is the live show with our B.V.ACHARYA garu. Once again, a fundamental issue, infringement of fundamental rights, very clearly explained. Now it is to every citizen, you keep writing to the Supreme Court, keep writing to the Prime Minister, President, all concerned. That is how we will try to make them to understand that people have understood that this law is of a draconian nature. So do support DRTSPR channels. They work in larger public interest with wonderful guests like B.V.ACHARYA ji. Thank you very much, sir. Thank you very much. Good night from here. Take care. Bye.